Hi guys, it's been way too long since I've posted a video. I hope you guys are well, and yeah, anyways, welcome back to my channel and welcome to today's video. Okay, so if you're new here, igama AsandaNtini, and I am an admitted attorney. I do content on all things law. No. If you're new here, Gumelo Tandu Jesu. Oh my word, I can't speak. I don't know what my intro used to be 10 days ago. Anyways, yeah, the last video I did for specifically my content on attorney or candidate attorney tips and whatnot was the matter of unopposed matters that you might be facing. Let's speak about opposed matters. First things first, how would you know that your matter is opposed? I'm going to speak about this in the context of a civil application. So I'm going to be specifically speaking from the Magistrate Court Rules. I'm going to direct you. So if you are dealing with a matter, the rule that you go to is Rule 13. The moment you received a Rule 13 notice, that is a notice of intention to defend, you must know that, all right, Ziakala, I am now opposed. This, if you are the person who's supposed to be opposed, so you get in the office one day, your principal says that a matter has been opposed, that we've just received new instructions and I need you to oppose this. What's the first thing that you look at? You look at the day in which your client receives the summons. When did they receive that notice of that action that's taking place against them? This is, I'm speaking specifically on an action. There's different things, dates for applications. So specifically, if it's an action, I'll do a video on what's the difference between an action and an application. I'm doing these things in reverse, but yeah, that's the next video. So 10 days after summons have been served, a notice of intention to defend must have been received. If you don't send a notice of intention to defend within this time, the matter may be set down as though it is unopposed. But let's say you receive your summons and your client receives summons and they're like, yeah, I've received them correctly and they were served, not just affixing them in an address. Look at the rules, look at if proper service was done before you do like anything else. You're going to receive that, file your notice of intention to defend immediately before even doing a plea or thinking about a plea, especially if you receive them like maybe 7 days after they've received. This is the one thing that courts allow you to bring after 3. Because it's a notice of intention to defend. Like you can run and say, I'm here to bring the notice of intention to defend. Like they'll allow you to file after 1. So yes, this is the only thing that you are allowed. So if your action is within the jurisdiction, you have 10 days. If it is outside the jurisdiction, you have 20 days. But 10 days, guys, 10 days, because a lot of times people have a local jurisdiction, so they're unlikely to serve you papers outside of jurisdiction. I mean, not local jurisdiction, but a local correspondent. They're unlikely to send you papers from outside of your jurisdiction in order to avoid the issue of you pleading Ogba, you are out of the jurisdiction. But actions that are against the minister, deputy minister, provincial premier, office or servant of the state. So if you are defending or if you are suing the state, they have 20 days. They have 20 days simply because those people are overworked and they are tired most of the time. They're likely not going to see your papers very early. So they are given 20 days. Unless, obviously, if the court authorized a shorter period where maybe you are doing an urgent matter. But if it's not an urgent matter, 20 days. All right. So where do you deliver this notice of intention to defend? You deliver it to the address that's on the summons that was given and make sure that well received, they sign for it. Or if it's by sheriff, you have a return of service. Because sometimes you don't even know where the person is. It's always better to say, let me send a sheriff to do this so that they come back with their return of service. That's how you initially put to record that this matter is now defended. Then the next thing in an action is that you file a plea. Maybe you file a counterclaim, whatever your client's instructions are. And then they respond to your plea as well, your counterclaim if they want to respond. You request further particulars in terms of Rule 16. So you send a notice in terms of Rule 16. Like, I hear your cause of action, but what are you saying? I mean, like, what are you saying? I can't respond to this without any further particulars. And you can also raise a special plea. If people send you papers that you can't even say, I want further particulars, but you want to raise a special plea, maybe whatever that you want to raise as a special plea, you raise a special plea if you want to do that. Then, say for example, you now pleaded and you're like, okay, my client no longer wants to fight this, they are not ready. Rule 18 applies, offer to settle. So now here, the reason why I'm bringing this up, do not sign or remove the matter from being opposed without getting all of the things of settlement signed. And if it means that I'm going to pay you, the person maybe he receives their payment first before you withdraw your intention to defend. Don't do that. Do not sign things like that if you're on the other side or whatever the case might be. Make sure that you get those things. And exceptions. So where, as I've spoken about, special plea. An exception, this is where a pleading is vague and embarrassing or lacks averments which are necessary to sustain an action or a defense. The opposing party who intends to take exception shall, within a period allowed for filing any subsequent pleading, deliver an exception as provided for in paragraph A and B of Rule 19. A classic case of exception, I'll put the citation here, where this person was suing FNB for their spouse having an affair. The special plea stood and the matter was withdrawn from the labor court simply because court said, guys, you all are too much in Joburg. It was 5 paragraphs. It's one of the funniest judgments I've recently read, and it's an old judgment. It was like, you guys in Johannesburg are too adventurous. It's not in the labor court, it's in the high court, I think. You guys are too adventurous. People will have affairs. To go and ask the employer to be accountable or to basically pay for the sins of your wife is like, you just are wild. People will have affairs and they'll continue to have affairs. We can't expect employers to lendozana to just be held accountable for that. And that was funny. Anyways, yeah, so those are some of the things that you bring in an opposed application when you're opposing. And then if it means that, okay, we are now closing pleadings, like people have discovered all of that. I mean, not people have discovered, but we've done our plea, we've done our counterclaim, and the plea, a replication and the plea in reconvention has been done. Let us close pleadings. Either party is joined in the issue without alleging any new matter. The last day allowed for filing replication has died. Okay, if I say words like that on YouTube, I'm going to have my thingy strike off. I'm not speaking about the other D. I'm speaking about dies in terms of lactin days. Okay? And then the parties agree in writing that pleadings are closed. That means that you're not going to be filing other things. People fail to deliver pleadings, you have an option of barring them, because there are a lot of people that file a notice of intention to defend with no intention of ever defending, but just making you wait for the sake of waiting. We don't have days forever, so you bar the people and then they have to do an application to uplift the bar, whatever the case might be. So once that is done, you then set the matter down for trial. Since you guys are not coming into an agreement, since you guys just want to fight, you set the matter down on trial. Ensure that it's set down on the opposed role, because if it's not on the opposed role, they're going to put it in motion. Then it turns out it's not there. Then the presiding officer will be upset, and then they'll say, strike the matter off the roll. Then you need to start again and apply for a date, and then you need to explain to your client what happened. If you're a candidate attorney, you need to explain to your principal what happened, and then it's not going to be a good day for you. Anyways, yeah, So once the matter is set down for trial, that's when documents are discovered. And sometimes that's when often, once matter is set down for trial and documents are discovered, people are like, oh, whoa, okay, I didn't expect this. Let's go on a round table and try to discuss. With that said, make sure if you received a notice of intention to defend, just know your matter is opposed. If you are doing not a civil matter, you are doing like a labor matter, and you filed an application and it says within 5 days respond to this, because that's usually the days that are in matters like before forums. I mean, in terms of the labor court, the CCMA rules, do that in 5 days after receiving the papers. Put in your notice and reply within those 5 days. And then if you are in labor court, it's usually 10 days after receiving. All of that, make sure you are within the days to file the notice. Most importantly, notify the person, I'm about to oppose you. Be ready, so that the person now knows, okay, I need to go back to my client as well. Okay, with that said, thanks for watching and all the best. Make sure, guys, your rule books are your friend. If you don't have the book, these things are readily available on the internet. Make sure you know how to navigate the internet in relation to legal research and making sure that you are in line with the rules in your particular practice area. Because if you don't know rules and directives, you are going to be in trouble. With that said, good luck, and yeah. Dies are about to come to a dies none. 15 December is very close. We are about to have rest. So, yeah. Have a blessed day. Bye.